Call this Rockridge Public Schools special meeting on November 19th, 2024 to order. I would ask everybody to please rise and recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands. Any discussion on tonight's agenda? No. All in favor signify by saying aye. Aye. Opposed? Motion passes unanimously. First item up is the consideration of potential removal of a school board member. Can I get a motion?
I'll make the motion.
Motion by Director Yuhan.
Support.
Support by Director Lotiger. Any discussion? Any discussion? Any discussion? With none being had, this will be I would ask Director Lotiger to please read the resolution.
Resolution removing a school board member. Whereas the district hired Joshua Hagum as independent investigator and attorney to probe the allegations of misconduct against board member Pollyann Sorkin. Whereas Mr. Hagum conducted a comprehensive investigation into the allegations against Ms. Sorkin, which included an interview of Ms. Sorkin and submitted his final report to the district. Whereas individual school board members reviewed and carefully considered the findings outlined in Mr. Hagum's investigation report. Whereas the school board determined the results of the investigation provided a legitimate basis to move forward with the proposed removal of Ms. Sorkin from the school board and passed a resolution to that effect at a meeting held on October 28th, 2024, where Ms. Sorkin was present and voted against said resolution. Whereas Ms. Sorkin was provided 4 separate opportunities to be heard in defense against the allegations during the investigation, at the October 28, 2024 school board meeting, through allowing Ms. Sorkin to request a due process hearing, and at the November 19, 2024 school board meeting. And whereas Ms. Sorkin failed to timely request a hearing and was given notice of the fact that her failure to do so would be deemed to constitute acquiescence to her removal, and that the school board would have the authority to proceed directly to take action to remove her. Now, therefore, be it resolved by the School Board of Independent School District number 2909, Rockridge Public Schools as follows. The school board is satisfied that Mr. Hagum's investigation fully and completely examined the allegations against Ms. Sorkin in a neutral and unbiased manner. Ms. Sorkin was also given a full opportunity to respond to the allegations with the assistance of legal counsel during the investigation. The school board finds the conduct described below and described in more detail in the investigation report constitutes proper cause for the removal of Ms. Sorkin from the school board. Specifically, the school board finds that Ms. Sorkin has committed malfeasance and nonfeasance while in office through conduct that has affected the performance of her official duties as a school board member. Malfeasance is not susceptible to an exact definition, but generally means misconduct in office and refers to and includes only such misdeeds of a public officer as affect the performance of her official duties to the exclusion of acts affecting her personal character as a private individual. State versus Burnquist, 170 NW 201-203, Minnesota, 1918. The school board finds the following conduct constitutes malfeasance. Ms. Sorkin's conduct in contacting attorney Martin Melang, an attorney who represented a plaintiff in litigation adverse to the district on February 28, 2024, violated the Code of Ethics for board members set forth in School Board Policy 209. Her fiduciary responsibilities to the district and constituted malfeasance. That communication was made in an attempt to take private action that would compromise the school board, to undermine decisions of the school board because of personal disagreement rather than support them, and to work against the superintendent and her colleagues on the school board rather than with them. By way of example, the following findings in Mr. Hagum's report support this conclusion. On February 28th, 2024, Sorkin called Martin Milang's law firm and spoke with someone there and left a message. Milang is an attorney who had been representing an individual named Catherine Disterhaft in one of the lawsuits about the school buildings. Shortly after this attempted call, sometime in March 2024, Milang began representing Richard Klobachek in a different lawsuit against the school district regarding school buildings. During her interview, Sorkin stated she was calling Milang about a personal matter, but it was about the school buildings, and she felt I had, in quotations, I had my individual citizen hat on at that time. She had been paying attention to and had private information as a board member about the Disterhaft case. She called Milang because she knew he had represented Disterhaft in the litigation, and she also saw in the court records that Milang had recently withdrawn from representing Disterhaft. Sorkin called Milang's office because she felt he did not represent anybody at that time, and because she was asked to call him by interested people who felt the same way as Sorkin, that the building should not be demolished and should instead try to be saved. She was asked by one of these other individuals to call Milang because she was familiar with the case, the rationale, and the pleadings. Sorkin has a duty to support the decisions of the school board, work with the superintendent and her colleagues on the school board, avoid conflicts of interest, refrain from taking private action that will compromise the school board or the school district itself, even if she disagrees with the decisions made or action taken by the school board. Sorkin's stated intent and purpose for contacting Milang is contrary to these duties because she was attempting to overturn or help others overturn a decision the school board made to demolish the school buildings. Sorkin claims she was acting in her individual capacity in communicating with Milang's office. However, it is illogical to conclude that she could, in quotations, remove her school board hat when contacting Milang because she was contacting Milang about official actions that had been taken by the school board, which were matters of school district business. She also used information she obtained in her official capacity regarding a lawsuit on this issue when contacting Milang. Finally, as recently as a few weeks prior to her call, Milang had been actively involved in litigation adverse to the school district on those very same issues, which took up time and created expense for the school district in an attempt to compromise and overturn the decisions made by the school board. Indeed, shortly after this call, Milang began representing another individual in a second lawsuit against the school board related to the demolition of buildings. Nonfeasance is described as the neglect or refusal without sufficient excuse to do that which is the officer's legal duty to do. Jacobson versus Nagel, 96 North NW 2D 569, 573, Minnesota, 1959. The school board finds the following conduct constitutes nonfeasance. Ms. Sorkin's conduct in forwarding an attorney-client privileged email from Squires, Waldsperger, and Mace, PA, to Milang on February 29, 2024, violated the Code of Ethics for board members, set forth in School Board Policy 209, as well as her fiduciary responsibilities to the district, and constituted both malfeasance and nonfeasance. This communication was made in an attempt to take action that would compromise the school board, to undermine decisions of the school board because of a personal disagreement rather than support them, and to work against the superintendent and her colleagues on the school board rather than with them. The communication exhibited Ms. Sorkin's neglect and refusal to uphold her duty to guard the confidentiality of data. By way of example, the following findings in Mr. Hegum's report support this conclusion. After Sorkin called Milang's office, Craig Hardy, an associate attorney who works with Trevor Helmers at Squires, Waldsperger, and Mace, sent an email to Sorkin at her school district email address with the subject line in bold and in quotations, confidential, subject to attorney-client privilege, end quote. The next day, Sorkin forwarded the email from Hardy to her private email account at 2:04 p.m. She then responded back to Hardy at 2:11 p.m. from her personal email account in the following manner. Mr. Hardy, I made it clear to Mr. Milang's receptionist that I was not, in capital letters, calling in my capacity as a school board member. Regards, Pollyann. At 3:51 p.m. that same day, Sorkin then forwarded her reply email to Hardy to Milang from her private email account with a copy to the same private email account, including the original email from Hardy that was marked, in quotations, capital letters, confidential, subject to attorney-client privilege. As noted in the School Board Code of Ethics Policy, Policy 209, Sorkin has a duty to maintain the privacy, confidentiality, and non-public nature of the data contained within the emails she is forwarding. In fact, she was specifically instructed by Helmers on March 1st, 2024, that the email he sent her on that date, along with all other correspondence sent to her by his firm, is protected by the attorney-client privilege. And in quotations, it is a violation of your fiduciary duties to the school district for you to either forward this to a personal email address and or share it with any third parties, including personal attorneys that you may have, end quote. Ms. Sorkin's conduct in forwarding another attorney-client privileged email from Squires, Waldsberger, and Mace, PA, to her private email account on March 4th, 2024, after she was specifically instructed not to do so, violated the Code of Ethics for board members set forth in School Board Policy 209 and constituted malfeasance and nonfeasance. That action was made in an attempt to take private action that would compromise the school board, to undermine decisions of the school board because of personal disagreement rather than support them, and to work against the superintendent and her colleagues on the school board rather than with them. That action exhibited Ms. Sorkin's neglect and refusal to uphold her duty to guard the confidentiality of data. By way of example, the following findings in Mr. Hagem's report support this conclusion. On March 1st, 2024, Milang forwarded Sorkin's email, including all the previous messages, to Helmers and Hardy to inform them of the communication. Helmers did not consent to direct communication between Milang and Sorkin, and instead proposed for Milang to prepare a statement to Sorkin that Helmers and Hardy would then forward to Sorkin, and Milang did so. Helmers then forwarded Milang's statement to Sorkin at 12:58 p.m. on March 1st, 2024. Despite being clearly directed not to forward the email, Sorkin forwarded that email message to her private email account on March 4th, 2024 at 12:41 p.m. Sorkin understands that by her act of forwarding emails from her school district email account to her private account, she is creating government data. During her interview, there was discussion with Sorkin and her legal counsel about the concerns with her storing and creating government data on her private email account. As part of the investigation, this investigator made a request of Sorkin and her legal counsel for specific data from Sorkin's private email account that related to attorney-client privileged emails from the school district's legal counsel, along with any emails relating to official school district business. Sorkin's legal counsel responded to this request on August 28, 2024, providing various emails that had been sent and received over the past calendar year. The emails provided included communications with staff, legal counsel, and private citizens, and discussed subjects ranging from policies, statutory and legal requirements, student issues, legal matters, and other school district happenings, among other things. As noted in the School Board Code of Ethics Policy, Policy 209, Sorkin has a duty to maintain the privacy, confidentiality, and non-public nature of the data contained within the emails she was forwarding. In fact, she was specifically instructed by Helmers on March 1st, 2024, that the email he sent her on that date, along with all other correspondence sent to her by his firm, was is protected by the attorney-client privilege and quotations. It is a violation of your fiduciary duties to the school district for you to either forward this to a personal email address and or share it with any third parties, including personal attorneys that you may have, end quote. In response, a few days later, Sorkin forwarded that very email message to her private email account, violating the directive the school district's legal counsel had given her not to do so. Ms. Sorkin's use of her private email account to conduct school business, receive and transmit confidential communications, and store government data violated the Code of Ethics for board members set forth in School Board Policy 209 and constituted malfeasance and nonfeasance. Specifically, Ms. Sorkin's use of her private email account exhibited Ms. Sorkin's neglect and refusal to uphold her duty to guard the confidentiality of data. Additionally, her actions made it more difficult for the district to guard the confidentiality of data. By way of example, this conclusion is supported by the following. Sorkin forwarded 383 emails from her school email account to her private email account, approximately 250 of which were emails sent to the entire school board. And she sent 17 emails from her private email account to her school email account. The examples of the emails provided relate to all manner of school district related activity, including, among other things, emails from community members and staff members voicing concerns, emails sent by the superintendent providing status updates to the school board on various matters, emails sent to the school district's legal counsel regarding ongoing litigation marked as, in quotations, confidential, end quote, and or, quote, attorney-client privileged, end quote, and emails from the plaintiffs involved in two separate litigation matters against the school district, Catherine Disterhaft and Richard Klavacek. When asked if she can understand why the school district would be concerned when they can see all these various types of emails containing private, confidential government data going to her private email account with no way of knowing where the emails might go after that, she said, in quotations, not really, end quote. As detailed above, Ms. Sorkin's conduct violated several provisions of the Code of Ethics School Board Policy 209. The lack of respect for and adherence to the Code of Ethics generally exhibits her neglect or refusal to uphold her duties as a school board member. By way of example, this conclusion is supported by the following. Ms. Sorkin's conduct, as described in paragraph 3A, violated sections A5, B5, F1, F2, F4, F5, F6, and F7 of the Code of Ethics School Board Policy 209. Ms. Sorkin's conduct, as described in paragraph 4A, violated sections A5, B5, F1, F2, F5, F6, and F7 of the Code of Ethics School Board Policy 209. Ms. Sorkin's conduct, as described in paragraph 4B, violated sections A5, B5, F1, F2, F5, F6, and F7 of the Code of Ethics School Board Policy 209. Ms. Sorkin's conduct, as described in paragraph 4C, violated sections F1, F2, and F7 of the Code of Ethics School Board Policy 209. By choosing to communicate with individuals who have been actively involved in litigation against the school district, including attempting to communicate with an attorney who represented those individuals, especially when the timing of those communications was in close proximity to or during the time those individuals were involved in lawsuits against the school district, Sorkin created both the appearance of impropriety and actual impropriety. The conduct described above demonstrates that Ms. Sorkin abdicated her responsibilities as a member of the school board in favor of her personal, private interests. In addition, Ms. Sorkin has demonstrated that she is willing to use her authority and influence as a member of the school board to further her personal, private interests. Lastly, Ms. Sorkin has demonstrated that she is unwilling to guard the confidentiality of data shared by the district's attorneys for the purpose of acting to undermine the decisions of the school board. Such conduct violates her fiduciary responsibilities to the district. The school board finds that Ms. Sorkin was provided the required due process before being removed from the school board. Due process requires, in quotations, notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them of an opportunity to present objections, end quote. Armstrong versus Manzo, 380 U.S. 545, 550, 1965. Specifically, the school board finds the following facts and circumstances satisfied Ms. Sorkin's due process rights. Ms. Sorkin was notified of Mr. Hagem's investigation into her misconduct and was interviewed by Mr. Hagem as part of the investigation process. During and after that interview, she was given an opportunity to be heard in response to the allegations and presented objections in her defense. Ms. Sorkin was notified that the school board would consider adopting the resolution proposing removal of a school board member at its October 28, 2024 meeting, and she was provided a copy of the same before the meeting took place. At the October 28, 2024 school board meeting, Ms. Sorkin was in attendance and had an opportunity to respond to the allegations against her in front of the school board when it voted on the resolution. At the same meeting, Ms. Sorkin voted against the resolution proposing removal of a school board member. The resolution proposing removal of a school board member specifically provided Ms. Sorkin the right to request a hearing within 10 days of its passage on October 28, 2024, which would have required the district to arrange for an independent hearing officer to conduct a hearing and issue written findings of fact, conclusions, and a decision on whether Ms. Sorkin may be removed from the school board. Ms. Sorkin elected not to exercise that right by failing to timely request a hearing, for which she was provided notice that her failure to do so would constitute acquiescence to her removal from the school board, and that the school board would then have the authority to proceed directly to take action to remove her. Ms. Sorkin waived her third opportunity to be heard on her proposed removal. At the November 19th, 2024 school board meeting, Ms. Sorkin was provided her fourth opportunity to be heard and present objections to the school board's proposed action prior to a final vote on the matter. The school board is satisfied that the investigation and the school board proceedings that followed the investigation provided Ms. Sorkin a full, fair, and meaningful opportunity to be heard in her defense. Ms. Sorkin is hereby, I think number 9 would be pending, I can read it
No, let's,
afterwards if
yeah,
need be.
let's do that. It's, okay, with what you guys heard, is there any discussion amongst board members, Bill?
On C, I would say that I don't remember her being given an opportunity to talk to us after we had our closed meeting and came out.
Yes, she did.
Did we, I know she said, you guys haven't even heard me. You haven't even asked me
There was discussion prior to going into the closed session.
She talked after also.
There was discussion after the motion was made also. There was discussion after the motion was made, where she had an opportunity to speak?
Yeah, was she given that opportunity?
Yeah, absolutely.
I didn't see that opportunity. And I remember her saying, you guys haven't even given me an opportunity. Just
I
throwing that in
think
there.
Lisa is correct in saying that.
Any other discussion amongst board members regarding this? With this, we will do a roll call vote. Okay, I'll start with Director Reardon.
Yes.
Director Reardon is a yes. Director Lotiger.
Yes.
Director Lotiger is a yes. By the way, you're voting to remove as a yes, okay? Director Yuhan.
Yes.
Director Yuhan is a yes. Director Addy is a yes. Director Colbert Dahl.
Yes.
Yes. Director Colbert Dahl is a yes. Director Westby.
No.
Director Westby is a no. Motion passes 5-2, or 5-1, excuse me. 5-1. With that,
I can complete.
would you just start at 9, please?
Ms. Sorkin is hereby removed from the School Board of Independent School District number 2909 Rock Ridge. And then number 10, in November 2025, the school board will hold a special election to allow the voters to decide on Ms. Sorkin's permanent replacement for the remainder of her term, which expires in December 2026. And Member John Yuhan introduced the following resolution and moved its adoption. The motion for adoption of this resolution was duly seconded by Member Director Lotiger, and upon a vote being taken thereon, the following voted in favor of the motion: Reardon, Lotiger, Yuhan, Addy, and Dahl. Whereupon no vote was Director Westby. Whereupon said resolution was declared duly passed and adopted 5-1.
Members of the board, I just want to make it clear that upon the removal of a board member, you have a time period between February and November to replace that. You have to go to a vote. So I just want you to know that.
So on here, it's not, we shouldn't really have November 2025. It could be sooner than
That's
that.
the last date you can legally do it.
Right. Okay.
Nothing further is on the agenda.
With that, I will ask, item 4, with the resolution of removal passing, I will move along to 4, which is adjournment. Can I get a motion to adjourn?
So moved.
Moved by
I'll
Lotiger,
second it.
support by Westby. All those in favor signify by saying aye.
Aye.
Opposed? Motion passed unanimously. This meeting is adjourned.